Hello everyone, so good evening and welcome once again to my YouTube channel. It's a pleasure to have you here. I'm so excited today. Obviously I'll be continuing from where I stopped last week, where I talked about the principle, resource exploitation as a principle in international space law, and we were able to bring it down to some simple major steps. So I'll be continuing from where I stopped last time. And today we are going to be discussing on a key element in international space law, which is the legal framework of the international space law. And today we are going to be concentrating on one of them, which is the Outer Space Treaty of 1967. So you may be wondering, what exactly is the Outer Space Treaty all about? And that's what I'm going to tell you about today. So apart from the Outer Space Treaty, we have other agreement, we have other framework that guard the activities of outer space, such as the Moon Agreement of 1979. We have the Rescue and Return Agreement. We have some other important agreements like that, but today we're going to be focusing on just one, which is the Outer Space Treaty. So I'll go further to tell us the history of the Outer Space Treaty, how it came about, and then some key contents of the Outer Space Treaty, which are instrumental to the understanding of outer space and the runnings of outer space. So I want you to follow me, like this video if you think you have enjoyed me thus far, subscribe, and then let's see how we go from here. So we proceed. Okay, so the outer space from our screen here is also known as Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. The Outer Space Treaty was considered by the Legal Subcommittee in 1966, and agreement was reached in a General Assembly in the same year. The treaty was largely based on the Declaration of Legal Principles Governing the Activities of States in the Exploration and Use of Outer Space, which had been adopted by the General Assembly in its resolution 1962 in 1963, but added a few new provisions. The treaty was opened for signature by the three depository governments, which include the Russian Federation, the United Kingdom, and the United States of America, in January 1967, and it entered into force in October 1967. So this is a brief history of how the Outer Space Treaty came about. But before the Outer Space Treaty we see that the United States and USSR then, led by Nikita Khrushchev in 1957. According to Khrushchev then, he said that USSR had superior intelligence of space, and because of the fact that they had launched into space earlier than the United States, obviously, and the fact that communism should be accepted because of the fact that they were able to launch into space for any other country. But then we had the likes of Eisenhower then as the president of the United States of America, who was later succeeded by John F. Kennedy as the president of the United States of America, who was very much interested in launching into space. So we see that all these activities sponsored the resolution that there should be a treaty that governs space activities. As a matter of fact, there's more than the Outer Space Treaty. I mentioned the Moon Agreement, I mentioned the Rescue and Return Agreement, and there are other agreements that govern the activities of outer space. However, the degree to ratification also differs. So today we're looking out for the Outer Space Treaty, and I've talked about the brief illustration of how it came about, naming three nations as the first signatories, which include the United Kingdom, the United States, and then USSR as it was then. So those are the three states that founded it. Currently, as of March 2024, we have 114 countries who are ratified to the Outer Space Treaty. So moving further, we'll be talking about some key principles or elements. I didn't want to go into just going after article after article so that I won't bore you, my audience. So I broke it down for you with the help of the United Nations Office for Outer Space Affairs, UNOOSA's illustration of the Outer Space Treaty. So Article 1 to Article 15 or 16 of the Outer Space Treaty have accordingly been dealt with in such a way that it can be understood by virtually anyone. So moving further, we'll go forward to establish the principles that have been laid down in the Outer Space Treaty of 1967. So the first one here is that the exploration and use of outer space shall be carried out for the benefit and in the interest of all countries, and shall be the province of all mankind, as recorded in Article 1 of the Outer Space Treaty. Similarly, outer space shall be free for exploration and use by all states. This also contains Article 1 of the Outer Space Treaty. Outer space is not subject to national appropriation by claim of sovereignty by means of use or occupation or by any other means. If you have not watched my YouTube video on the principle of non-appropriation, this Article 2 of the Outer Space Treaty is very instrumental in understanding the principle of non-appropriation, which to the extent that no state party, no country can own any part of space. As it currently stands, no country can own any part of space. So no one can claim sovereignty or nationality in space currently. And then the next one is that states shall not place nuclear weapons or other weapons of mass destruction in orbit or on celestial bodies or station them in outer space in any other matter. This is contained in Article 4 of the Outer Space Treaty. This puts restriction on state parties to ensure that whatever they do in outer space, they should not plant nuclear weapons in outer space. And this has helped to curb the activities of certain countries who may have had in mind to do that. Next one, the moon and other celestial bodies shall be used exclusively for peaceful purposes, as contained in Article 3. Okay, so the previous one I talked about just said that there should be no bombs, no atomic bombs planted, no nuclear weapons planted. This one goes forward to say only peaceful purposes should be what the outer space should be used for. Anything other than that will bring sanctions to the state parties involved. Next one is astronauts shall be regarded as the envoys of mankind. Okay, so what this Article 5 of the Outer Space Treaty tries to talk about is that humans, okay, who are astronauts obviously, shall be regarded as the personnel. Some countries have changed the word envoy to personnel, as noted. Some countries have changed the word envoys to personnel. Okay, so personnel is going to be easier to understand as people that will get into space, the legal people that can go into space. Because obviously you can't get into space with your normal body. You have to go in there fully covered. So you can't just go in there on your own accord, because you end up coming out, you might even make it up there. You should just be fully clothed and ensure that you are fully dressed up in a way that you can get into space and come out properly. So also what this one talks about is the fact that animals should not be envoys. Okay, humans are not properly clothed, prepared for space, should not be envoys. And then the next one is that states shall be responsible for national space activities, whether carried out by governmental or non-governmental entities. Okay, so states shall be responsible for national space activities, whether carried out by governmental or non-governmental. This one talks about principle of responsibility of states. I think I talked about that in my last video on non-appropriation. States are responsible. States are responsible for whatever goes on. So if a private entity, for instance, like Planetary Resources in the United States, which is specialized in mining asteroids, gets into space and then there's a problem, probably it's an orbital collision or something like that, the United States of America are the ones that are responsible for the activities of Planetary Resources. Okay, yes, so Planetary Resources won't take, that's what we call vicarious liability in law of torts. I think it also applies here in space law. So the country that sends its entities, whether it's governmental or not governmental, that country shall bear responsibility. So anything that goes wrong to the country, that should bear responsibility. So private entities are advised that before they go into space, they should ensure that their countries are aware of it. The United Nations are aware of it. There's a particular treaty to that effect, and that the United Nations are aware of the fact that they want to launch to space before they launch to space, so that proper care can be taken. Because any mistake, any mishap that comes in, it is that country that will take responsibility for it. Next one is that states shall be liable for damage caused by their space object. damage caused by their space object. So I talked about this already. This is Article 7. Just is continuation of what I just said. If there's a damage in any way, in any form, it is the country, the state, that should be responsible for such damages. So accordingly, private entities, governmental and non-governmental entities are warned to be careful of the activities on outer space. We also have that states should avoid harmful contamination of space and celestial bodies. Harmful contamination of space and celestial bodies. I think that's easy for you to understand. That's easy for you to understand, pretty much. The next time we're talking about another legal framework of the Outer Space Treaty, which is the Moon Agreement. So subscribe, like my channel if you love what you saw, if you learned a thing or two, and then obviously we'll be back next week. Thank you very much.